Face is red.
Good afternoon and welcome to episode number 41 of At Your Service with Haber and Martinez, a disheveled Martinez today. I'm Mike Haber and that's Ed Martinez on the other side, and we're here to talk to you today a little bit about the Fifth Amendment and Miranda. I've titled today's show, if our producer Mike would be kind enough to put up the first slide, we have a series of slides to help us get through this hour with y'all. Our first slide, if you take a look at the upper left-hand corner, you'll see a selfless plug, a shameless promo. This is something that I created a while back. I call it hashtag UpX2. Ed and I have mentioned this on the show many times, and what it really is just a very simple way to remember your two basic constitutional rights when it comes to the subject of the three C's, cops, courts, and constitutions. That is, invoke the fifth, shut up, and invoke the sixth, lawyer up. Ergo, UpX2. Thanks, Mike. You could take that slide down. So UpX2, in thinking about show topics, Ed and I decided why not go with UpX2 and break it into a two-part series. The first part, shut up. The second part, lawyer up. We're going in amendment order, starting with the Fifth Amendment, and then next week or the next show, hopefully it'll be next week, will be part two, lawyering up the Sixth Amendment. But today we're going to talk about the Fifth Amendment. And we've broken today's show down into a couple of different sections. And the fundamental starting point is going to require just a little bit of history. As Ed pointed out, nobody needs the History Channel when they've got me around.
Oh, yeah. You love this stuff.
I do. I do love history. I do love etymology. And I want to talk a little bit about the Fifth Amendment, how it is, what it is, and actually, y'all should know what it is. So many of you don't. Many people just think the Fifth only applies to one's privilege against self-incrimination. But there's more to the Fifth. Mike, would you put up slide number 2 for us? Thank you. So this is the Fifth Amendment. And for those of you who may not be able to read script, kind of cursive, kind of like my son, and most students in today's day and age, let me just read it off to you real quick. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Thank you, Mike. You can take that one down. Okay, so let's go through a few of these things on the Fifth Amendment real quick. Let's start with the first thing that it talks about, which is grand jury indictments. Ed, go ahead and tell the folks what a grand jury is.
Well, a grand jury is basically what it says it is. It's a jury, but not a jury for a jury trial. It's a jury of people, of peers, of unbiased people who come in and the government presents their case. And I know a lot of people say, well, this is not fair. You don't get to present a case. But this is the preliminary part. This is just the very beginning where the government wants to know, based on everything that we think we know, do you think that's enough to arrest someone? Because if the government says this is the best we got, and the grand jury comes back and says that's still not enough, then great, nobody gets arrested. So it's really like a trial, but it's only for the government to say, this is what we have. Do you think this is enough to get this guy arrested? And then they have a chance to respond. So that's what that's for. And only in federal, by the way. Only in federal, because remember, Fifth Amendment is federal government. So that's what they always have to do an indictment.
We're going to get there. So basically, the grand jury is a non-adversarial proceeding. It's where the government has to take a step in order to get the approval to move forward in the criminal process. And the reason that we have a grand jury requirement was because the king wasn't subject to any of that in England. Remember, everything that we have in this country that stems from the Constitution comes from the idea that we do not want to be governed by a monarch who can wake up one morning and decide, you know what, I don't like that Haber guy and I want his ass in a jail cell.
If I may,
you want to say something?
Governed by a monarch who actually, that's exactly what they did. Not that we wouldn't want him to do it. This comes about because that's exactly how it used to happen. Monarchs used to be pissed and say,
Our
"I don't
founding-
like what you're saying. Go to
Our
jail."
founding fathers built this in as a check valve against the government's authority. Now, y'all have to remember, Ed brought up a very important point. I was going to get there in a minute, but I'll jump to it right
Sorry,
now.
man.
That's okay. The Fifth Amendment, along with the other first of the 10 amendments, which are known in this country as the Bill of Rights, were all ratified by Congress in the year 1791. They stopped at number 10 at that point. And the whole idea that the founding fathers had when they created the Constitution was to create a federal government that was extremely limited in power so that the individual states could operate as their own sovereign entities with their own set of rules and laws. And the federal government was designed to protect the individual states and to keep us unified as an organization, as an entity, as a nation, but never to be a king. So it wasn't until many years later, 1868, that the 14th Amendment was ratified. Now, the reason that I was going to come to that a little bit later is because there are a couple other things in the Fifth Amendment, and one of the biggies, the third one down the line, is due process. So just hold that thought for a minute. Let me hit point number 2 from the Fifth Amendment. The second thing that was thrown in there deals with a concept that we call double jeopardy. I don't want to get too much detail into this, but basically what double jeopardy means is you can't be charged or punished more than once for the same offense, but there's limitations on everything, including double jeopardy. So just to do a little myth busting with double jeopardy and an interesting little fun fact, if you happen to commit a crime that is a crime in more than one sovereignty, and that sovereignty can exercise both subject matter and personal jurisdiction over you, then theoretically, you could be tried twice for the same offense, but it wouldn't be double jeopardy if it's not the same entity.
Right.
So basically what double jeopardy means is the government can't take you to trial. They can't charge Martinez with murder, and then he gets acquitted, and then they decide they want to try him again because now they've got a new witness. No, one and done. They had their bite at the apple, and it's over. Now, let's say that it was a bank robbery, and let's say I committed a bank robbery and I was arrested and prosecuted for it in state court. I could be prosecuted and punished consecutively, in fact, for that same exact bank robbery as a matter of federal law as well as state law. So you see they're different sovereigns. But the point was, if the king didn't get you the first time, that's okay. All he had to do was throw you in a cell and try you again and again and again until he finally got you. And so that was one of the things that our founding fathers said, no, we're not going to allow. So double jeopardy is also there in the Fifth. And then the third point is due process. And that goes back to what Ed was saying about the Fifth Amendment and all of the Bill of Rights, technically up until that point, only applying and binding the federal government and having no bearing on the states. So it wasn't until the 14th Amendment was passed that the same identical due process protections, which we're going to talk about in a minute, were specifically given to the individual states. Actually, I shouldn't say given to the individual states. I should say imposed upon the individual states. Because due process basically comes in two functions, two forms. There's procedural due process and there's substantive due process. And they're very different, right? But basically what they are is, either way, they're a safeguard against government authority in terms of any infringement upon your life, your liberty, or your property, right? So procedural basically means that you're entitled to notice and an opportunity to be heard in front of a neutral and detached trier of fact, a fair judge or jury.
Right.
Impartial.
By the way,
that's basically all that's required.
And by the way, and I've heard judges say this, believe it or not, Michael, picking a jury. It is not a jury of your peers. Okay? There's a lot of myths. We're going through some of these myths here, right? That's one of my biggest pet peeves. You do not get a jury of your peers, because if Michael gets arrested for something, a jury of Michael's peers would be 50-something-year-old males.
There's not that many short, fat, bald white guys.
It's not. It's absurd. It is a fair and
it's an impartial panel from your community.
That's it.
So, but I don't want to stray too far on that. Let's go back to due process.
But we got to get rid of some of these myths, and we got to make it light and fun, because You're getting into it, man. You're teaching a CLE here.
Well, we're going to get through it real quick because I want to get to the meat and potatoes, but the history is important.
It is.
Apart from procedural due process, we have substantive due process, and substantive due process basically protects you against vagary, right? So it requires specificity in laws. It requires that laws be pursuant to legitimate governmental authority and not just executive fiat or whim. It's why when a president signs a what do you call those things they sign?
Executive order?
Proclamations or executive orders. That's great, unless the court says, nah, you didn't have the authority to do that. You exceeded. Right. That's what procedural due process is. And then we get to, before we get to the number 4, which is actually our topic today, I want to skip to number 5 because it's the last part of what the 5th gives us. The 5th has 5 parts. The 5th is a limitation on what's known as eminent domain. That's where the government comes in and says, hey, nice piece of property, but we need it because we're building a highway, or we need a military base, or we need an easement, or whatever. They can't just usurp your property like the king used to be able to do. If the king wanted a new highway and he wanted to bulldoze your house, guess what? Goodbye, house. Here in this country, our founding fathers said, look, we're not saying the government can't do it because it may be necessary, but they can't do it on fiat and they have to compensate you. They got to be fair about it.
Right.
And again, it ties into that substantive due process at where you are entitled to notice an opportunity to be heard in a fair and neutral determination.
And it's not just stuff like a highway. Remember back in that time here in the colonies, the king was sending over soldiers and saying to the people that lived there,
room and
you have
board,
to house them and
yep,
feed them, and they weren't going to give you any compensation for it. So they
let you live, maybe.
Well, that was the compensation, right? So it goes beyond all of that. And here's Mike. If I just want to say this so everybody understands. The reason, and I agree with Michael, that the history is extremely important is many times when we talk to clients or we talk to people, and I've talked to lawyers and some judges, if you don't understand the historical background, some of these comments and some of these terms are very abstract and vague, and you don't really understand it. You need to understand what was going through the mind of our founding fathers at the time that they did this, so you can really get an understanding of what these amendments mean, juxtaposed with the backdrop of what was going on at the time with the king and how it used to be. So,
by the way, apropos of this, I'm wearing my "Don't Tread on Me" shirt.
I saw that.
I'm not into reptiles, but don't tread on me. All right. Now we get into the final point, which is actually number 4 chronologically in the 5th, but it is the main topic today, so I held it to last, and that is the privilege against self-incrimination. And really the reason that was in there is you all know it, whether you know it or not.
Right.
When the king wanted to try you, it was a lot easier when he had a confession. Because if there was a confession, they didn't really have to go through a whole ordeal or a trial because, right, you did it. You admitted you did it. Now we can get right to the important, fun stuff of how are we going to punish you. So it was not uncommon for the king's men to use methods of extracting confessions, such as torture. And so basically what our founding fathers said was, no. And the other thing was, there was a presumption, and actually there still is in a way, although not as quite as much as it was more medievally, but there still remains a presumption of guilt in many places, including England, as opposed to our written presumption of innocence. So there was a presumption back then that if you didn't speak in your own defense, if you chose not to say anything when you were accused, you must be guilty because you're not saying you're not guilty. So our founding fathers had foresight. Go ahead.
No, I want to expound in a minute. Keep going.
All right. So our founding fathers had the foresight to say, number one, we don't want people to be tortured into giving confessions, whether they're true or false. It doesn't really matter. And number two, we want people to be able to exercise a right to remain silent without generating a presumption based on invocation of the right. And so that's basically what the 5th says. And everything that Ed and I are going to talk about after whatever it is that he's going to say right in this moment. But after that, the rest of this conversation is going to be way past 1791 and 1868. In fact, we're going to go all the way up to 1966 when the case of Miranda versus Arizona was decided. And we're going to talk to you a little bit about Ernesto Miranda, after whom the famous Miranda warnings are named, and explain to you a little bit about how that happened. And then we're going to get into a lot of myth busting and practical realities and nuts and bolts.
So again, in keeping with the history, because you got to understand the history, prior to our system, and still, like you said, in many countries still, when you're accused of a crime, you get arrested, and it's upon you to prove you did not do it. Now think about that, Michael. How do you prove you didn't do something? That is almost impossible in most scenarios. It's almost impossible to prove that you did not do something, right? And going to the confession, since you did not have the privilege prior to our rights to remain silent and force the government to prove it against you, Michael's right. If you didn't speak, it kind of was assumed that you were guilty because you didn't want to say anything. However, it goes farther. It goes deeper. Think about it. It goes to, hey, Mike, the neighbor says that you set fire to his car. That's it. You're arrested and you're done. Unless you can prove to me you didn't set fire to his car. So if Michael doesn't speak, he's done because he has to prove he didn't set fire to the neighbor's car. So they were kind of like they forced you to speak. And the government here, our founding fathers realized, listen, that's not right. It's not fair, because if it's almost impossible to prove you didn't do something. Mike, prove to me that you're not an alien. How do you prove to me you're not?
I am an alien.
You can't.
I am an alien.
Well, there you go. So there's the confession.
I came through the southern border.
Right. When you think about it in those terms, and that's why I like what you wanted to do with this show, is give us a historical background. Because once you get that historical background frame of mind, you start to really understand how far ahead of the time they were, and how even today it is the absolute best system. Not perfect, but by far the best system that we have in criminal justice. All right.
So now that we've eaten up 25% on history, which is a good chunk, and it's important, and it's my passion. Let's spend the rest of our time talking about substantive issues that really affect us in today's day and age, and give you guys a real understanding. And myth busting is going to be a lot of fun. But Mike, if you would put up slide 3A, I'd appreciate it. I want to talk to you a little bit about this gentleman right here that you're looking at on the screen. That is Ernesto Miranda. So Ernesto was arrested by the Phoenix Police Department, and he was charged with kidnapping and rape of an 18-year-old woman. There was absolutely no physical evidence to tie him to the case. It was completely, utterly, 100% circumstantial. The police took him in, and they questioned him for 2 hours. After that 2 hours, he signed a written confession. Why is it that this is significant? Now, he was not beaten. There's no allegation he was tortured. He wasn't held over a rack. He wasn't deprived food or water. He wasn't held for days on end. He wasn't sleep deprived. He wasn't given drugs. He wasn't injected. He didn't have electrodes connected to his testicles. I mean, they did nothing to this guy. They just talked to him for 2 hours. But
although the last part, the electrodes connected to the testicles, depending on the charge, might not have been such a bad thing. It all depends on the circumstances.
So in any event, they arrested him, they took him to trial, and he was convicted of kidnapping and of rape. And the main basis of the conviction was his confession. And he had a court-appointed lawyer, believe it or not. It was a public defender named Alvin Moore. And Alvin had the presence of mind to make legal argument to the trial court that said that the confession needed to be thrown out because by the language contained in the very document, it was inaccurate. And here's the language. I want to read it to you exactly. Bear with me for 1 second. It said, quote, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement that I make may be used against me." So the first part of that was true. They didn't torture him. They didn't threaten him. There was no coercion. There was no promise of immunity. But the second part, with full knowledge of my legal rights, understanding any statement that I make may be used against me, was not accurate, because they never told him that. They never gave him his legal rights. Remember, prior to Ernesto Miranda's Supreme Court case, there were no Miranda warnings. So basically, the cops would put this in the form and then pass it off to a judge and a jury and a prosecutor and say, look, he signed it, he knew. And that was it, until Alvin Moore Esquire called them out. Well, it wasn't good enough. He was convicted in trial court, but the Arizona Supreme Court reversed on this ground. And it went all the way up to the United States Supreme Court, which turned around and said, yep, Arizona Supreme Court, you got it right. Arizona State Trial Court, you got it wrong. We're remanding this case back to your trial court for a whole brand new trial. As a result of this, the Miranda warnings were born. Now, before we get into the Miranda warnings, which we will in just 1 second, before we get into the Miranda warnings, I just want to give you a little postscriptum, because again, you know, my etymology and history penchant. As it turns out, Ernesto Miranda went back to trial for a second time on rape and kidnapping charges. And he was convicted again in state court. And he was given the same exact sentence in state court. And the reason he was convicted this time, his confession was excluded. It did not come into evidence. That was the whole point of Miranda versus Arizona, which is one of the myths that Ed and I will get to later when we talk about remedies. But his confession was not admitted into that second retrial. But what was permitted to come in was new evidence, because they now had a witness who claimed that he had confessed to her and admitted to her that he had done this kidnapping and rape, and her testimony was sufficient to convince the court.
Right.
So he was convicted. He got sentenced again to 20 to 30 years in prison on each count. That was in 1967. In 1972, he was paroled. And he spent the next several years up until 1976, actually January 31st of 1976. He went back to Phoenix. And you know how he made his living, Ed? Do you know what he did to support himself for the next couple of years?
I have no idea. No, I didn't know.
I shit you not. This is the God's honest truth. He made a living by autographing police officers' Miranda warning cards.
You're lying to me.
I'm telling. Well, that's what I have come to conclude on multiple sources in researching this today and yesterday. And then horrifically on January 31st of 1976, he was stabbed to death in a bar fight. So that's the story of Ernesto Miranda.
He couldn't win one, huh? He went.
Yeah.
He got paroled
Now,
early.
Mike, would you put up 3B for me? Everybody knows what the Miranda warnings are, okay? I mean, we've all heard them before, but I'm going to read them off to you so that
you read them, but I'm going to give you explanation I used to give.
Hang on, before you do that, I'll hold off on that, because I want to do two things first. First, I want to read you the actual Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. What you're looking on the screen is what I call Miranda for the millennia. And this says, you have the right to remain silent. You grant us a non-exclusive, irrevocable, sub-licensable, worldwide license to use anything that you do say in any medium now known or later developed, including against you in a court of law. Thanks, Mike. You can take that one down.
Yeah, so that sounds like something you'd have to say today, because I have no idea what that meant.
Well, what it basically means is what it says. Anything that you say is capable of being resaid, whether it's going to be republished in the newspaper, whether it's going to be published on social media, whether it's going to be restated by a third party. I mean, all one needs to do is look at, and I know it's not criminal, but all one needs to do is look at Johnny Depp and Amber Heard, and you can think about all of the things that one of them has allegedly said about the other, and everybody who's now coming in to repeat these statements and bolster credibility and testimony. None of that happens when you keep your yapper shut. Okay, and we'll get to that a little bit later.
Right. And we're also going to explain, and again, the way I used to try to explain it, because I always try to make things very simple, would also explain to you, why is it that you don't need to give a Miranda warning? In other words, why did Amber Heard have to give a Miranda warning to Johnny Depp?
Civil.
Why didn't the people who testified that said, Johnny Depp said X to me, or Amber Heard said this to me, why didn't they have to get a Miranda warning? It's very simple. Miranda or the Miranda warnings, and we'll refer to it as Miranda, only, now listen carefully, only applies to custodial interrogation. You need both, one without the other. It's like making a cake. You need all the ingredients. If you're in custody but you're not being interrogated, there's no need for Miranda warning. If you're not in custody but you're being interrogated, there's no need for a Miranda warning, and it also has only to do with a government actor. So, a person from the government. So what happens? So a person who's sitting next to Johnny Depp at a club is not a government actor, just some person. So there's no need for that. But let's say I'm an undercover, or let's say we arrest you, Michael. Let's say I'm wearing a uniform and I arrest you, but you're free to leave. You're not in custody. Let me rephrase that. Sorry. Let's go first one. I arrest you. You are in custody. I arrest Michael Haber. He is in custody because when you're cuffed, you're in custody. Now, the law says that some other things, before you get cuffed, you may or may not be in custody, and that would be a 2-hour show. But for a fact, the law says once you're cuffed, there's no doubt you're in custody.
If you're
so
arrested.
Michael is cuffed, and I say to him, Mike, how's it going, bro? And he says, man, I'm sorry. I didn't mean to shoot this guy in the face.
Well, hang on, let's not. You're jumping way ahead. I know you don't mean to, but
give me a minute. That is not an interrogation. So you need both. I'm just giving a brief example. You need both. You need the custody and the interrogation. You can't. Miranda does not trigger. They do not need to read you Miranda unless both are there. And that's the basis, the foundation.
Mike, put up number 4 for me real quick, please. Because I wanted to do this first. Okay. And
you just hate that I stole your thunder because you love your little pictures, your little memes.
I'm happy with the slides because they kind of work with us. And now we're going to go to number 5 real quick. So cops have to read you your rights, right? If you're in custody, that's what it's talking about.
And
they're interrogating you.
Right.
Go to number 5, Mike, please. So when is it required? We're going to take a look at number 5, and number 5 is going to be instructive. Slide 5, Mike, if we can get it.
Well, just start talking about it till Mike can get it.
There we go. So here's a little Stu's cartoons joke. Am I under arrest? The cop replies, and require me to advise you of your rights? I think not.
Correct.
Go ahead, Mike. No. Pop up number 6 real quick. I'm just going to run through a few of these because they're going to facilitate our discussion. It's another Stu's views. Number 6, please.
Well, while he's getting up number 6, notice what the cartoon says. Am I under arrest? The cop says, basically, no, because then I'd have to read you your rights because he's interrogating him.
Here's another one. Here's a traffic stop. Miranda warning. No, this is just a routine traffic stop. You don't get Mirandized until after you finish incriminating yourself.
Right.
You could take that one down as well. And then hang on, just one more here. Put up number 7, please. We have ways of making you talk. Coercive tactics. All right, so thank you. You could take that one down.
Crackers for Polly.
All right, so I wanna do it this way. These are some examples, and what Ed is talking about is 100% accurate. And rather than throwing them at you, let me give you some. I'm gonna hit 5 Miranda myths, and we'll debunk them one at a time, which I think will take us through all these steps.
Go.
All right. The first one. Myth number 1: if the cops don't read you Miranda, then the arrest is a bad arrest. Now, that is a myth. Let me say it again. If the cops arrest you but do not read you Miranda, then it's a bad arrest. Or otherwise stated, if the cops arrest you and they read you Miranda, it's a good arrest. Okay? These are both myths. And why are they myths? For exactly the reason that Ed said and exactly the reason that our slides just showed.
Look, Miranda. The case of Miranda proves it right there. His confession was kicked out, but they still tried him.
Well, that's actually a separate myth. But yes, you're right. The point of the myth is Miranda warnings are enforced to protect against the unlawful admission of a confession that was illegally acquired.
And that's it.
And that's it. That's all it affects. It doesn't affect anything else. So the case itself, just as was the case with Ernesto Miranda, because the Supreme Court didn't say, oh, you guys blew it, that's it, case over, he walks free. No, he had to go back and be tried all over, but the remedy was the confession is excluded. The rest of the trial went on, and not only did the trial go on, but as the government did in 1967 when they retried him, they still do the same exact thing today. They tax you, right? The minute that you levy an assault on them, they go on an all-out mission to try and bury you. And if you don't believe me, you talk to any defense attorney who does litigation and files motions to suppress or motions to disclose confidential informants or motions to dismiss. And what happens? The state says, we're pulling out of plea bargains. At this point, we're seeking the statutory max. And then they'll double down and try and throw more charges if they can. Go ahead, Ed.
Let me say it let me give the state's point of view without the charged language, Michael. You're such a great defense lawyer. Without all the charged language, what happens is this. Good prosecutors, I used to say it myself. We have a saying. We either mitigate with an M, we either mitigate or we litigate. Now, if you choose to litigate, means you're filing motions and you're trying to suppress confessions, then it's like saying to a boxer or somebody, let's get in the ring and start throwing punches. State isn't going to just sit back and take the punches. You throwing punches, they're going to fight back. So it's not that they're doing it nefariously or well, some do. Let me be fair. Some do because there's bad apples in everything. But in some cases, you put yourself on the radar or you basically tell the government or the state, listen, we just want to start throwing punches. Forget about it. The time to talk is over. We're going to go to war. We're going to launch rockets. And they're not going to sit there and try to negotiate while you're launching rockets. They're going to launch their own rockets right back. So if you go down that road, you got to know that even the most fair-minded, justice-minded government actor like a prosecutor is going to start launching rockets back. And they're going to look for crimes. Because if you're the victim, let's say Miranda really did rape a girl. Now, I don't want to get into the facts of it, but let's say he really did. The community and that family would want a prosecutor who's going to look for every piece of evidence to prove that Miranda did it. So Miranda
which begs the question, why didn't they do that in the first place?
Because once they thought they had I'm just saying, again, don't kill the messenger. But they might have said, well, we got the guy confessed, to hell with it. Let's move on to another case. We already got this one in the bag.
Which is what we were talking about with the king, how he used to do it, right? They got their confession. What more do they need?
Once you get a confession, you got it in the bag. And I'm sure, look, it's 1960 what? 66? 64, whatever.
66.
In a Mexican in Arizona, you got a confession on a Mexican in Arizona who raped a woman who probably was not a Mexican woman. Listen, you're done. Miranda's done with that. So they figured, we got him. Let's move on to another case. But I wasn't there. So I'm just speculating.
Let's go to myth number 2, which is basically similar to myth number 1. It's just restated. If the cops skip Miranda, then all evidence is inadmissible. It's kind of a tangent to the first. No, that's not true. The only thing, the remedy for a Miranda violation is exclusion of any ill-gotten statement. That's it. That's the only remedy. There is no other remedy. Your case doesn't get dismissed. You don't get a ticker tape parade. You don't get a Medal of Honor. Your statement is excluded, and that's the only thing that's excluded. Everything else comes in. So if I get arrested and I have a grow house, for example, and the cops don't read me Miranda, they've got me handcuffed out on the sidewalk and they're grilling me, and I make a confession that's un-Mirandized, it doesn't mean that, assuming everything else was legit, there's no other basis to suppress anything else. It doesn't mean that the drugs or the lighting or any of the equipment or any of the other evidence that they found that shows my guilt is excluded. No, Miranda only applies to the suppression of ill-gotten or illegally gotten or unconstitutionally acquired statements. Number 3, myth number 3. I read my own handwriting here. If you invoke per Miranda, then your silence can be used against you. So let me restate that a different way. The cops tell me I have a right to remain silent, and I'm afraid to remain silent because I don't want them to say in court, oh, when we asked him what happened, he didn't say anything. He must be guilty. No, that is a major myth. Ed, have fun with that one.
Well, honestly, I haven't had a lot of clients ask me that question, but occasionally they.
But you've had a lot of cases where a prosecutor has attempted to make a comment on the defendant's right to remain silent.
Yes, and there are some times. I'll give you an example that I had. I'll give you a war story. I know everybody loves the war stories, right? So I had a case. I was a prosecutor. I was in narcotics.
Are you going back to the Trojan War?
Yeah, very funny. We had co-defendants, brothers actually, that went to do a 2 kilo buy from police officers. I don't remember where, and it ended up in a shootout. The older brother, the career criminal, he was a career criminal. He came in and was intent on ripping off the CIs, the confidential informants, and there were 2 of them in this case. And you hear him tell, all on video and audio, man, it was really good quality too. Steven Spielberg would have been proud. You hear him turn to one of the guys and say, "You sit right there, you're cool." And then part of my French, he turns to the other guy and says, "But I'll shoot you in the fucking face. Go get me the cocaine." But there were like 15 cops in there. And he takes off running down the hallway when he gets his coke. Mike, I shit you not, 15 cops shot that man, only one in a corridor, in a hallway. They all missed him. Like what's his name in Pulp Fiction?
It's like stormtroopers. Yeah, like stormtroopers who never hit a person in their lives.
No, or Samuel Jackson when the bullet just go. Nobody hit him,
intervention.
Except the oldest officer who was about to retire, who made the last shot, and he got him right in I think it was the right or left butt cheek. But his brother was driving the getaway car. Now, his brother had priors, but his brother didn't have to testify, right? Because you got the career criminal. He knew he was done. He's on video. He's done. So he's the only one who testified trying to save his brother. If his brother doesn't testify, can't bring in all the priors, right? But one thing happened, and I actually went to trial on that case with Andrea Wolfson, Judge Wolfson. She was my second chair on that case. Now, Andrea had more experience than me, but it was my case. So she came with me on the trial because she wanted to try it was a really fun narcotics case. So she wanted to try it with me. But an issue came up, and Andrea and I discussed it, or Judge Wolfson, forgive me. We discussed it, and we both agreed not to make a comment, even though I think we may have been able to. So let me tell you what the issue was. He hears the gunshot. His brother comes running out of a warehouse. It had been raining, there's puddles, and he had to park about 4 spaces away. His brother is limping down the street with a bullet wound in his butt. He's got about 15 police officers chasing him. 2 cops come out and grab the getaway driver, the other brother, grab him by the throat, drag him through the window of the car, put him face down in a puddle, step on his neck and tell him, if you fucking move, we'll kill you. Then they cuff him. Then they pick him up. Then they drag him out. It took about 15 minutes, and not once did he ask, what the hell's going on? Right? Pretty damning. In a situation like that, I believe that that's a situation where I might have been able to say, a normal, reasonable human being that did not know what we were there for would have asked, what the hell's going on? However, that's a situation that's a close call. So Andrea and I, Judge Wolfson and I decided at the time, it's not worth the risk to get an appeal and have the case reversed. So let's not even mention it. Let's just see if the jury picks up on it. They've got videos. They've seen what happened. If they pick up on the fact that the guy never once asked what the hell was going on, let's just leave it at that. That's a situation that was a close call because of all the surrounding effects. But typically, you can't comment on it. And even in that situation, we knew we probably shouldn't make any comment that he didn't ask what the hell is going on. So you can't. The prosecutor really, it's really thin ice when you start commenting on what he didn't say.
In really simple terms, your invocation of the fifth, your choice to remain silent, is not evidence. In fact, it's specifically excluded from evidence.
One thing I want to add, I'm sorry. The reason it's a close call is why? Because he hadn't been read his Mirandas and nobody was interrogating him, right? So could I say that he didn't say anything? Maybe,
The-
but it's risky. It's very
The
risky.
the general rule and the myth busting fact is your right to remain silent is sacrosanct. Nobody can comment on it other than
Right.
saying you have a right, a fundamental Fifth Amendment right to remain silent, and it cannot be used against you.
Even in my scenario where nobody asked him anything, but he still has a right to not say anything. That's how we felt it, and I think Judge Wilson and I made the right decision. I think we did the right thing there. By
And
the way,
so
the brother walked. By the way,
that takes us to myth number 4, that the right to remain silent is in the Constitution, which it actually isn't. There's no such thing as a right to remain silent. It is a privilege against compulsory self-incrimination. What the Constitution says, what the Fifth Amendment says is, you cannot be compelled in a criminal courtroom to be a witness against yourself. Now, why is that not the same as a right to remain silent? Because it isn't. Don't say right to remain silent.
it just isn't.
And there's a collateral to it, which is it only applies to criminal cases, which is why when Johnny Depp sues Amber Heard, he doesn't have a Fifth Amendment right. He's got to testify. And she doesn't have a Fifth Amendment right. She's got to testify. But where is this applicable to our world? Let's take a really good, simple, everyday example. Domestic violence cases. Ed and I are roommates. We get into an argument. It gets labeled domestic. One of us gets arrested for battering the other. The one that gets arrested cannot be compelled to testify, cannot be compelled to give a statement. I could be taken in front of a judge. I could be prosecuted. I could be booked into the jail. I could be taken to trial, but nobody can force me to take the witness stand. But if Ed turns around and takes out a civil restraining order against me based on that very same fact pattern, if he goes in front of a civil judge and says, Judge, I'm in fear for my life. I need protection against Haber. I don't want him in the same house with me. He's dangerous. He's violent. Here's my reasons. And if the judge agrees and issues a temporary, I now have to appear for a civil hearing. And if I appear for a civil hearing, I have no ability to invoke the Fifth because the Fifth doesn't apply to civil hearings. So I either must testify, or if I choose not to, which I can do, in that civil arena, and by the way, this holds true in administrative arenas as well, such as like the Department of Highway Safety and Motor Vehicles, or if you're in front of some licensing board or the Florida bar or whatever, the medical boards, you have no right to remain silent. And your refusal to speak can actually constitute what's called a rebuttable presumption of guilt. In other words, if Ed gets a restraining order against me and I show up at that hearing and I say, Judge, I'm not going to testify because I have an open pending criminal case. Let's say I actually am using my Fifth Amendment privilege in criminal court, my pending case, as a barrier to testifying in the civil case. The judge can look at me and say, too bad, so sad. If you don't testify, I'm going to presume that you're guilty. And I'm going to give the restraining order to Mr. Martinez.
And they can move forward with their civil case, their injunction, which is another thing that maybe people need to understand is, I think this is also a myth busting related. How many times have you had this, Michael, where they call you for a temporary restraining order, an injunction, and they think it's criminal? That is civil, which is what Michael's talking about. Believe it or not, it's a civil act. So the judge can move forward with the hearing. Now, most judges in Dade County will give you 1 or 2 continuances, hoping that you can close it out because they're trying to be fair. But the law, the precedent, and case law is crystal clear. The judge has full discretion. They can say no. They can say, sorry, we're going forward today.
There's no rule that they're required to continue civil matters pending the resolution of criminal. Now, that said, most judges are going to be fair and reasonable, and most judges are not going to put you in that pickle play where you're forced to choose between your constitutional rights in criminal court and defending yourself in civil. Some will. It happens. I've had it happen to me in my cases.
On the first time? Because I've had it happen on the second.
No, I've had it happen, but either way, it don't matter. Most judges are not going to do it at all. Even if it clogs up their own arteries, they're not going to put people in that position. You know what? It doesn't pass the stink test. And judges have to run for re-election. They don't want buzz going around. They don't need people trashing them. And if they make an honest, fair, reasonable determination that just doesn't work to your advantage and you're bitching about it, that's one thing. But when they're patently unfair about it, that's a completely different. Let me get to the last of my 5 myths. And this one is a biggie. This is a very important one. Miranda is automatic. It is not automatic. You must invoke. Now, this applies to the up X2, both points of it. There's no automatic invocation of your rights, and nobody can invoke your rights for you. You must unequivocally, and this is more applicable to part 2, to when you invoke your right to a lawyer, but either way it applies in both. You must make an unequivocal invocation of your rights. You need to say, I am invoking my Fifth Amendment privilege. I am invoking my Sixth Amendment privilege. I am invoking my right to remain silent. I am invoking my right to a lawyer. Now, if I surrender you, or if Ed surrenders you, let's say we broker a deal with the police, yeah, we're going to tell them. We're going to make sure they're very well aware, and we're going to do it in your presence. And what are we going to do? We're going to make sure that you say it right after we do, so that there's no mistake and no confusion and no ability for the police to argue, oh, well, we have it right here on videotape from our lobby of our police station. The lawyer invoked, but the defendant didn't. So we're going to give them no opportunity. You guys need to know you must do that. That is on you. Hashtag up X2. Invoke. If you don't, you blow it. So let me recap.
In fairness to law enforcement, I've done this many, many times as a defense attorney over my career. And I got to be honest with you, Michael, not once has an officer violated that. Most of the times, I tell him over the phone, right? I'll call him. My clients will call me and say, hey, a detective called me. He wants me to come in to talk. And and there's a good time to segue into that. Never do that. If an officer says, hey, we want to talk to you, or Michael, have you had this one? The officer calls your client and says, hey, we have something of yours. It's here. We need you to come look at it and see if it's yours. And then you show up at the station and they arrest you. They can do that. They can do all that. If a cop calls you, says he wants to talk to you, I'm telling you now, you get a lawyer and ask the lawyer to call him and ask him what's it about. Now, I know I have 3 questions that I ask the officers. I'm not going to share that on Facebook because, a lot of lawyers will try and take this from me, but it's very effective. The 3 questions that I ask them, depending on their response, usually will tell me whether my client's going to come in and talk or not. 90% of the time, it's no.
Are they like the same 3 questions from the Holy Grail? What's your name? What's your quest? And what's your favorite color?
No. I'll tell you. I think I've told you, but I'll tell you again afterwards. Anyway, depending on the response, and usually when they tell me, I'll tell you one of the questions. One of the questions I ask is my client a suspect? And if they say yes, then 90% of the time, I got to tell you, most of the time, on the phone with them, I'll start laughing and they'll start laughing because they know what my next thing is going to be, which is always, sometimes they've said it to me. Yeah, got to be honest with you, he's a suspect. And then they always say, so I guess he's not talking, huh? They know and they respect it. Usually, I'm telling you, I've never had a problem with at least law enforcement in Dade County, Florida.
Let me recap a few things because we're running short on time and I want to hit a couple of important points. I just want to recap, when is Miranda required? Okay, so Ed talked about this early on and we touched on it a little bit afterwards. The 2 key words are custodial interrogation. Both are required. You must be in custody. You must be interrogated. So warnings are necessary only in these types of custodial circumstances. So that begs the question, what is custody, right? Ed told you if you're arrested, if you're handcuffed, there's no question that you're in custody. If you're in a jail, there is no question that you're in custody. If the cops want to come and try and question you in a jail, they have to read you Miranda. They have to give you the opportunity to be able to say, no, I now understand my rights. Unlike Ernesto, they actually have to explain it to you. And now we do written forms, which is not always, it's not required, but it is the better practice, because that way the police have a physical document that you've signed that proves they've read you each and every one of the rights that you have to initial one by one by one. And then at the bottom, yes, I understand them. And either yes, I'm willing to waive and speak with you, or no, I want my lawyer and I'm not going to talk to you. So those are easy ones, right? But there are other circumstances where you could go, like Ed said, the cops might dupe you into coming to the police station under false pretenses, and you go ahead and speak with them. You may not be in custody even though you're at the police station because you're there voluntarily and you're free to leave. If you're there voluntarily and free to leave, you are not in custody, even if you're at the police station, even if it's under false pretenses. So again, it falls on you to have presence of mind to know, shut up, don't speak, or as Ed said, better yet, don't go. Always get your lawyer to handle it for you.
Just don't go.
So that's one.
They're gonna tell you all kinds of things, man. Mike,
And
let them know.
here's
They're
the
gonna tell
test.
you.
Here's the test, by the way, because obviously after 1966, the Supreme Court has had many occasions to discuss Miranda because issues have popped up in the last, 60 some odd years or
To this
50
day.
some odd years, right? And so each time it does, the court kind of refines everything and speaks to it a little more. And one of the things that they've said is that the test for determining whether or not you're in custody is called reasonableness. It's a reasonable belief that one is not free to leave law enforcement. So now there is also case law, because now I know some of you are thinking, well, wait a minute, what about a traffic stop? If I get pulled over for speeding, I'm not free to leave. If I leave, I'm going to get arrested for fleeing and eluding. So I must be in custody. No, that's a carve out. The Supreme Court has said a routine traffic stop is not custody for purposes of custodial interrogation. But if they handcuff you on the side of the road, now you're in custody. So everything that you say up until that point, every word that comes out of your mouth, Mike, please put up slide number 8. Every word that comes out of your mouth is admissible because you are not in custody. Here's slide number 8. Take a look at this guy. Anything you say can and will be used against you.
Held against you.
Can and will be held against you. Dolly Parton. Okay, you could drop that one down.
In the infamous words of Jack Reacher,
now,
details matter.
Why did I put that up there? Because it's a snarky comment, okay? And that snarky comment can lead to one of the last things that we're going to talk about today, and that is your lawyer having to wear a hazmat suit to court to clean up the mess that you
but
created.
before we get there, I want to just add one thing.
Oh, we're not there yet. I've got a few other things.
Because I do want to talk about one of my pet peeves about keeping your mouth shut.
So mere presence with law enforcement is definitely not enough. It's got to be custodial, okay? So again, if you're not in custody, or you are in custody, but you're not being interrogated. So let's say that the police have taken me into custody, they've handcuffed me, they've arrested me, they've thrown me in a holding cell. They don't have to read me Miranda unless they want to question me. Right. Now, if I'm sitting in that holding cell having a conversation with myself and speaking out loud, every word that I say is free game. If I call a police officer over and I start chatting him up, it's all free game. And by the way, even if I invoke, they're not allowed to question me anymore. But if I initiate discussion with them after invoking, the whole process starts all over again.
How about something they do routinely? If you're sitting in the back of a patrol car and you're talking to yourself or your co-defendant suspect who's looking at getting arrested with you, everything you guys say comes in because you're in custody, but you're not being interrogated.
So it's one of the reasons why on occasion, police officers will put co-defendants in the same cell or in the back of a squad car because they know it's wired for sound and they're just hoping you guys are going to yap because then they're going to get free confessions or free statements against interest.
Even things like, hey, don't say anything. They have nothing on us. Don't be stupid. Just stay quiet because that makes it look like you're hiding something. Even if you had the best of intentions and what you really meant was, we didn't do anything wrong. The road to hell is paved with good intentions. Just shut up. Don't say anything.
Let me hit a couple more things because again, we're running real short on time. I wanna talk about 3 concepts that are exceptions, and Miranda will not apply to. All right, 2 of them you find in the evidence code right here in the state of Florida. If you look at Chapter 90. Statute 90.803, which are exceptions to the hearsay rule. Right. And the first one, 90.803 subparagraph 1, is called a spontaneous statement. And a spontaneous statement is, quote, describing or explaining an event or a condition made while the declarant was perceiving that event or condition or immediately thereafter. And then number 2, the second hearsay exception is called an excited utterance, and it's very similar. A statement or excited utterance relating to a startling event or a condition made while the declarant was under the stress of the excitement caused by the event or the condition. So where do we see these two things? 911 calls. Every single 911 call, pretty much, not everyone, but 99% of them are spontaneous statements and excited utterances. Why? Because in that moment that you call 911, you are experiencing something. It's usually not 2-3 days later that you call 911. It's right when it happened, right? I got hit, I got beat, somebody shot at me, somebody cut me off, whatever happened on the road, blah, blah, blah. It's in that moment. And it's a direct statement and response. So there is a presumption of trustworthiness based on the timing and the circumstances. But the corollary to that is one of Ed's pet peeves. I'm going to let him run with for 60 seconds, if he can limit himself. And that is something that's called the self-serving statement.
And this is why it's my pet peeve. Most people get in trouble when you talk on the side of the road, either making excited utterances, spontaneous statements, or even after you've read Miranda talking, because you think, I want to say my side of the story. Listen,
or you think you're going to talk yourself out of something.
Either way, let's say you legitimately want to say your side of the story. You're innocent. You didn't do it, and you want to explain why you're innocent.
Okay? Oh, I'm sorry. One more thing. Mike, can you please put up slide number 9? Self-serving statements.
What does it say? I see that you're married, so you already know that anything you say can and will be used against you. So listen.
Go ahead. You could take that one down. Go ahead. I'm sorry. Listen, I didn't mean to interrupt.
You think if I just tell the cop my side of the story, he won't arrest me. Okay. Anything you say that would benefit you at that moment, if you get arrested, we can't use it. We can't go to trial and say, again, Michael, cop is asking you, the neighbor says they saw you setting fire to his car in his driveway. And Michael says, look, I didn't set fire to my neighbor's car. It's impossible. I couldn't have set fire to my neighbor's car because I was at my girlfriend's house at 3:00. None of that would come in unless his girlfriend would come in and testify. But the fact that Michael told him that on the side of the road, the jury will never hear it. They'll never hear that very moment he said that, because it's considered a self-serving hearsay statement. The only exception, which we complicate things again, I don't want to complicate it, is if we can show that what Michael said to the cop at that moment was a consistent statement to what he's saying in trial today. So number one, Michael would have to testify. That's the first problem. He would have to testify at trial for us to bring it in. And if you're not going to testify, don't bring it in. Number two, think about it, guys. If we end up going to trial, you know what the jury's going to say? Of course he said that.
Right. What else is he going to say?
What else is he going to say? So it's a lose-lose for you. There's no way to win. Just shut the hell up.
Just to give you the exact definition, a self-serving statement is a statement made by a defendant out of court in his own legal interests, which serves no purpose and provides no evidentiary value except to reinforce the declarant's legal interests. And it is hearsay and it is inadmissible. Two more things I want to touch on. Please put up slide number 10, Mike. I talked about your lawyer wearing a hazmat suit. Obviously, that's a metaphor. Attorney, Mr. Phelps, can you please explain to the court how I did it and I do it again is just a figure of speech? You can go ahead and take that down. Anything you say can and will be used against you, okay? I don't care if you're joking about Dolly Parton or if you're making a serious comment, a joking comment, an inculpatory comment, an exculpatory comment, doesn't matter. Shut the hell up. Because whatever you say, Ed, I, or some other lawyer is going to have to explain away. And no matter how clever you think you are generally compounding your dilemmas and your difficulties by speaking to the police. I like to tell people there is a time and a place and a person to make the argument for you. It is never in the moment on the roadside or at the crime scene. It is never at that particular time when the cops are there, and it is never you. Your lawyer can say anything that you want to say, safer, because your lawyer's statements are not admissible as evidence against you.
It's hearsay.
Smarter, because we are trained in the rules of evidence. and in your interests, because we know where they will help you and where they will hurt you. And then the last thing I want to do is pop up our last slide, number 11, and we're going to close on this note. Let this sink in. This should be your guiding principle when it comes to speaking to the police. If you just think about any fish that you've ever seen on the wall, they always have their mouth open. They never have their mouth shut. Their mouth is always open. If the fish kept its mouth shut and never bit the bait, it wouldn't get in trouble. It wouldn't be on the wall.
And there's nothing, again, there's nothing for you. If you're going to say it, I'm going to give you a piece of gold, because some people, and I may or may not have been accused of this myself in my life, some people just can't keep their mouth shut, right? They feel like they have to say something. If you're going to say anything, you know what it is? Officer, I'll gladly talk to you as soon as my lawyer is present. You want to say that, knock yourself out, but don't say anything after that. No matter what he says, you should respond with, Officer, I'll gladly talk to you as soon as my lawyer is present, no matter what he says, because it doesn't help. And all it does is it'll get you mounted on the wall. That's all it'll do.
Mike, you could pull that last slide down. Thank you. All right, folks, we've taken up a full hour of your day. I hope we've given you some insight and debunked a few myths on Miranda. Maybe you've learned something. I hope you have. At least I hope we were a little entertaining and informative, if nothing else. And we are going to follow up with part 2 of hashtag UpX2. And that's going to be reference your Sixth Amendment right to counsel. And similarly, we'll go through all of the other rights that the Sixth Amendment incorporates and the why of them. And we'll give you practicality, reality, and pro tips. In the interim, I want to thank you guys for joining us today, for your patience, for your time. And we look forward to being at your service next week. Thank you, Ed.
Bye, everybody. Thanks, Mike.
Thank you, Mike. Appreciate all your help today with production.